Good morning, everyone. Welcome to Bar Talk, May 8th. We have a new executive order or two that is sitting out there in the governor's website. And the one that we just wanted to bring up briefly is Executive Order 51, establishing the Economic Recovery Committee. If you take a look at the order, asking this committee to determine what policies need to be put in place to help our economic recovery in Maine. And one of the first preliminary report is due not later than July 15th. So they're moving ahead with this pretty quickly. They're looking for subcommittees as well as committee members. And they do reference needing to consider the legal aspects of any type of policy too. We did send a letter on May 1st to the governor asking to have a seat at the table related to reopening Maine. And what we plan on doing is touching base with the governor's office to let them know we have an interest as representatives of lawyers to have a seat at a table, whether it's a subcommittee or otherwise. For those of you that might have a specific desire to be on this economic recovery committee or subcommittees related to maybe some specific industries and the legal aspects thereof. If you'd like us to help interface with that desire, please reach out to us either via email to me or Angela, and we will present your proffer and ideas. That being said, we now have a special guest on with us, Acting Chief Justice Andrew Mead, and he's graciously accepted our invitation to kind of give us an overview of what's happening at the judicial branch and the plan forward. Chief Mead, I see you're there. The floor is yours.
Thank you. Thank you, Thad, and thank you to the MSBA for the opportunity to have this forum. It's a great opportunity to get some of the information out there, and we appreciate it. I have a lot to say, but I'll try and truncate that down to about 10 minutes at the risk of maybe missing something, but there are some important things going on I want to bring everyone up to date on. But I need to put it in the perspective of what's happened. It's been a brutal 8 weeks for all of us, for all of you, and certainly for us on the judicial branch side. We have been basically reinventing what we do. That may sound like a simple task, but take it from me, it is very detail and policy driven, and it has occupied all of our time. Our efforts have been, our overarching efforts have been to respect the health and the lives and the public out there. That has been job number one, while at the same time making the courts available to the greatest extent possible. This is a vicious, virulent, highly contagious virus that is out there. It's a killer. It causes suffering and death, and we have a duty to the public. So we responded by issuing a series of pandemic management orders, PMOs, intended to address that. They were very ad hoc. We clamped down initially on all case types and limited the cases to people really who were in danger of being hurt or being killed, and those with constitutionally protected liberty interests. Since then, we've been addressing these issues day by day, trying to balance those issues of protecting health and safety against the court's role in providing a forum for adjudication of conflict, dispensation of justice. Our subsequent PMOs have expanded the case types that can be heard and the proceedings. It's been an incremental process, and that process has been driven by the definition of the priority cases. When I say priority cases, I'm not using that in a generic term. Several years ago, the court established a list of priority cases to be used in scheduling. We have limitations of resources. And as we dole out those resources, we have traditionally relied upon that priority list that continues to drive our decision-making process here. Originally, it was scheduled by the week. It was very ad hoc, week by week. We've now gone to 2 weeks by 2 weeks, and maybe at some point, we'll be moving to a monthly process. Our most recent PMO, as you probably know, opens up all case types with a few exceptions, but basically all case types with 2 provisions, 2 conditions. Number one, those case types must be susceptible to being addressed by video or audio conference. And secondly, is subject to judicial resources. Again, if the demand for processing those case types outstrips our judges, clerks, courtrooms, or hours, again, we will kick into the priority case list to govern the decision-making there. That's where we are right now, and I think we've reached a turning point. We are looking forward down the road, I think, to the big picture items coming down there. I think at one point this session was marketed as my vision for the future of the courts. My vision is to open all the courthouses, get back to business as usual. That's my vision. And I think it's probably your vision too, but that is not a plan. That vision requires a plan. We need a plan. And that is where we are right now. And that plan must be based on the science and the numbers. The science has evolved a great deal in the last 8 weeks. We have numbers now. We can look a little bit down the road. We, meaning the SJC, has gathered information and insight from organizations and other states, trying to get as much information that we can rely upon when we make our decision for the plan going forward, which will be after June 1st. What we're missing is input from you. We need to have the practitioners' insights from what's going on the ground. It's been 30 years since I was in practice, and I don't have the knowledge and the insights that you have. So what we're looking for is information, insights, and possible creative approaches. And to get that, we have set up 2 stakeholders meetings, Zoom sessions. We have invited organizations to attend and participate and share. We also have an open opportunity for folks not on that list to participate and share. And the other footnote to this is folks have taken us up on that. The numbers are growing. We may have to limit the presentations at the shareholders meetings to a period of minutes, but everybody, including the participants, people listening in, and anybody who wishes to submit comments, we have established a special email address for you to send it in. It doesn't have to be a fancy memo with citations. It can be an email you fire off. We're looking for what you know, what your information is on the ground, your insights. You know your clients, the constituencies you serve, and the special needs they have. Those are insights that we're not aware of. And then finally, this is the most important one, your creative suggestions on how to proceed. How do we open up the courthouses? We have some ideas, but they're still very much in the developmental stage, and we need to have your ideas in it also. The stakeholders hearings will not be a Q&A session, they'll be for presentations. We, meaning the judicial branch, will be there to listen to you. That will be the role. We don't have a plan right now for after June 1st. We simply don't have one. I know that if this was a Q&A session, most of your questions would start with when will, and then fill in the blanks, and how will, fill in the blanks. We don't have the when and the how. The stakeholders meetings will help us plan that, will inform our meetings. We will review all the information and every single submission that we get as we gather to plan through June. So again, I think our vision is a unified one. We've got to get the courts open. We've got to get back to business as usual, but we must do that safely. We owe that duty to everyone that comes before us. We will. We'll do it as a team. We will do it working within the profession and all the insight and submissions that we can get along the way. We are working night and day. This is not something that's on the back burner. It is occupying the leadership's time all day, all waking hours, and frankly, some sleeping hours too. but we are on it. And I appreciate this opportunity to get the word out. I hope to hear from a lot of you at or shortly after the stakeholders hearing. So I don't know if I brought that in with the time limitations here, but Thad, I'll hand back to you and ask if there are any specific questions or observations that you wish to pass on here, and I'd be happy to do my best to try and address them.
Thank you, Justice Mead. One of the things I want to let everyone know is there is a chat button here where you can type in a question. And
I've received some questions as
okay,
well.
good. I just wanted to throw out there too, Justice Mead mentioned that he has an email address for you to forward your concerns, your insights, and your creative suggestions. For those of you that don't want to forward them directly to the court, let's say, you may forward them to the MSBA, and we can forward those to the court too. So however you want to do that. With that, Angela, did you say that you saw some questions?
Yes, they were sent to me privately.
Okay. Go ahead.
Go ahead. Based on the court's orders for hearing, which are mostly via video conference or phone, should the same standards apply in administrative hearings, including med-mal, pre-litigation screening panels, and other such tribunals?
All of the case types that we'll be processing within the court system will be subject to those limitations, which are audio or video, subject to judicial resources. Any hearings outside the judicial branch, including medical malpractice, would be governed by those proceedings. In the medical malpractice setting, the medical malpractice chairs typically set up the scenario for how those proceed forward. And as the practitioners know, sometimes if there are discovery issues or orders that have to be passed on to the court, there is a procedure for that. But the med-mal proceedings and admin proceedings that take place outside of the court will be subject to their own specifications and provisions.
Thanks. I have a few more here. Is there any discussion about including some sort of designation to differentiate between the different versions of the PMOs?
I'm not completely sure what that question is. With the PMOs, along the way, we've seen what may appear to be conflicts, and we are working on trying to clarify those. We actually, in the most recent one, we're actually going to issue a clarification, perhaps in the form of an errata sheet, just to create clarity there. So to the extent that there may be a lack of clarity or inconsistency, we are working on that. It's difficult when you reinvent your entire processes of how you're doing things, and we'd like everything to be at the same level as the civil rules or the criminal rules, which get vetted, reviewed, and modified. So I guess the best answer I can give is we are working on that.
What communication is being given to the judges about lawyers wearing masks in the courtroom?
We have issued new directives on that. Our directive, again, this controls through the end of May, the current PMO, is that all persons entering the courthouses are required to wear face coverings, and as are the court personnel are required to wear face coverings when dealing with the public. A question did float to me through a back channel, which to the effect of, does that also govern the lawyers? You know, the lawyers are members of the public, and I think it would be disingenuous of us to say that members of the public need to protect themselves and others, but that wouldn't apply to the lawyers. So the answer would be yes. In dealings in the courthouses, in the public settings, masks are necessary. Obviously, with remote proceedings like this, they're not.
As you develop your plan, are you considering the high risk versus lower risk personnel?
Yeah, that's a good question. I'm sure you have this with your clients. We have this with our court personnel. We have some court personnel who are quite willing to say, you know, I'm in good health, I'm not too worried about this, but others who are at risk because of a condition or age or whatever, who have a heightened level of concern. And we need to fold all of this in, the concerns. So the answer is yes, we absolutely are considering that. You know, looking down the road, one of the big challenges will be jury trials, because jury trials by definitions are places where you compress large groups of people into closed rooms that may not have ventilators, don't have HEPA compliant ventilation systems. Some jurors would be okay, and other jurors would say, no, I'm scared, I don't want to come. So the jury question is a big one for us. That they are stayed at least through June, and if anybody has any creative suggestions, we'd love to hear it. There are some courts that are experimenting with settings in outside stadiums with the jurors wide apart and using the PA system as the way of communication. If there's some magic solution out there, we'd love to hear it.
Now, we are running out of time, Chief, but we did have at least 2 more questions. I'd like to limit it to that right now. Angela, do you have those?
I do. I
Okay.
do. So how are the video conferences scheduled by the courts? By motion, by counsel only?
As the chiefs and the SJC talked about that, we considered the possibility of creating a new list of unified rules for conducting video conferences, one size fits all. And that proved to be an almost impossible task. So the scheduling of the conferences are very localized. Different court locations have different hours, they have different staff on duty at times. So they are addressing it locally. We are going to watch and see how it occurs. And I don't have a particular answer to that. For you lawyers who practice in particular locations, probably your best bet is to touch base with those locations and ask how it's being done there. This will evolve. In time, we'll get it right. We'll have procedures in place, maybe even some master lists, but at present, it is very local.
And the final question we had time for was, if we have deadlines that were extended by 49 days under PMO2 and which are now coming up, are those deadlines extended again under PMO2, or should they be considered firm?
I think the initial imposition of the 49-day extension rule applied to the dates that came due at that time. They would expire at the end of that 49-day period. That's not to say we might not visit it again, but anybody who has a 49-day extension which is expiring, I would strongly suggest that you act as if that is the hard stop on that period. And
Chief, I appreciate you indicating that. I know we had briefly spoken about that this morning. And so I think in my calculation, that puts us with some expirations starting to occur on May 18th. So they're, or 19th, one of those dates, but it's coming. I think based on what we said is that you kind of have to take, well, like you just said, you have to take action into your own hands. If you've got an expiring date, look at the rules of procedure and file something.
Right, and as I say, I can't give you any advice beyond what's in the PMO, and right now the PMO does not have any, no PMO has any provision for extensions. Might one appear, I don't know. All I can say is if I was a lawyer and I was dealing with that situation, I would look at that expiration date as a hard stop and proceed prudentially from there.
So Chief, one other thing, and this might be somewhere where I thought I might have read it, but this is important. We've had a couple questions already about how do people listen in to the first and the second stakeholders meeting scheduled for, I think we've got one next week, right?
Yes, great question. I meant to cover that. I'm going very fast to try and get it in with my time limits. We will be streaming those sessions live through the law courts streaming page. If you go to the Maine Judicial Branch and go to oral arguments, there is a link on there which people can jump onto oral arguments at any time if you want to listen to oral arguments. We will use that same platform to stream the stakeholders meetings. So anybody, anywhere can log on to that. It's an open link to the streaming.
Now, if I remember right, Chief, that when I've listened to one of those streams before, that's just audio, isn't it?
Correct.
Okay.
Correct.
And we can also make sure that this connection information is put on our MSBA website too, to add, we'll get it out there.
Please, that's, again, thank you for the forum and for your getting that information out there. Anybody can tune it in and run it up on your site, and we'll have Cleves do the same thing. And there will be, I'll mention this also, trying not to take too much time. We will be sending an email notice to all folks who are registered as participants to explain all of these things, to get the word out that we'll sort of lay down the ground rules for the stakeholders hearing. We'll try and make it as productive as we can.
And just as a reminder to everybody, the dates of those are May 14th and May 30th, is that right?
I think is it the 21st? It's the 2 Thursdays. It's a Thursday and a Thursday.
Oh, it's a Thursday.
Yeah, I think it is the 21st. Yeah.
May 14th and May 21st.
Correct.
Thank you.
We'll make sure that we get that out. I know you did have it in the PMO too. Appreciate that, Chief. And thank you for joining us, and it means a lot to us. And I hope that you might be able to join us again if we're still in this pandemic.
We will, because we need to solve this as a team. We're all part of a profession, and we need input and assistance from everybody. So yes, I'd be happy to join you again.
Thank you, Chief. We just had a couple things to close the meeting with. Angela,
Okay.
can you put the agenda back on?
And I'll leave the meeting at this point. Thank you all.
Thank you, Chief. We've got, we're still in the middle of the Lawyer Wellbeing Week, and we've got upcoming guests next week that are listed on the slide. Anything else you wanted to add to that, Angela?
No, I don't want to hold people up. You can always visit this online at our website. All of this information will be available.
And I trust this little bit's going to help everyone here. We're thankful for our mothers. Don't forget your mother. We all have one coming on May 10th. Thank you very much, Angela. Bye, everyone.